Welcome, everyone. My name is Jeremy Kritt. I will be putting on today's presentation. I'm just going to give us a few more minutes here to see if anyone else who registered is running a few minutes behind. So we will be getting started just in a few moments. I appreciate your patience in the meantime. All right, why don't we go ahead and get started? For those of you who just joined, my name is Jeremy Kritt. I'm an associate attorney at the law offices of Marc J. Lane. We are corporate and tax attorneys, and a big part of our practice is social enterprises. And benefit corporations, of course, are a form of social enterprise. So why don't we get started today by doing a little poll question to get to know each other. So you have up here on your screen 4 options. Let's get to know each other by learning a little bit about your objectives for being here today. You have A, you want to start a business that has social and or environmental goals. You have a business that and you want to start pursuing those goals. You have a business that already does pursue those goals and you want to keep pursuing them. Or maybe you're just a consumer who wants to learn more about socially or environmentally responsible businesses. So I will give everyone a few minutes here to respond, and then we will get started. In case anyone didn't notice, today's presentation is being recorded. So I just want to make sure that everyone is aware. Okay, so it looks like everyone falls either into, oh, we got more responses. The most of you, it looks like, fall into A, B, or D. So either have a business or want to start a business that pursues social and environmental goals, or you're just an interested consumer. So let's use those objectives to contextualize the benefit corporation. So, you have those objectives, and what would be the appropriate entity structure to pursue those objectives? Well, on the one hand, you have the non-for-profit corporation, but the problem with this is a non-for-profit is only designed to facilitate social objectives. A nonprofit must be organized solely for charitable, educational, or similar purposes. And as the name implies, it cannot be operated for profit. It's limited in its commercial activity, and it doesn't have owners or shareholders. Nonprofits are considered to be owned by the public, so it can't issue dividends or make distributions. It has limited economic potential. Now, on the other end of the spectrum, the opposite end, we have the for-profit corporation. But the problem with the for-profit corporation is it's only designed to facilitate financial objectives. A for-profit may be organized for any lawful purpose. The management has no duty to consider to manage the corporation sustainably or consider social or environmental factors in their decision-making. And in fact, for reasons that we'll discuss and for more practical reasons, the decisions of management are typically driven by the goal of maximizing financial and shareholder value. And even if there is a social or environmental purpose, there's really no real legal mechanism to enforce those purposes. So the other thing I want to distinguish a benefit corporation from is the certified B corporation. Now, you may have heard of the certified B corporation, but the problem with the certified B corporation, it is related to the benefit corporation, but they are distinct concepts. Certified B corporation is simply a third-party certification, accreditation. It's not a starting point at all. You still need to choose an entity structure in order to get B Corp certified. So while B Corp certification has value, and generally, if you are a corporation that wants to get B Corp certified, you do need to become a benefit corporation. The point here is that B Corp certification, it's not an entity structure. It's not a starting point. So then what is a benefit corporation? Well, benefit corporations were created primarily as a response to the existing legal framework governing officer and director decision-making. Officers and directors of a corporation are fiduciaries of that corporation, that they have an obligation to manage the corporation in the best interests of the corporation. So what does it mean to manage in the best interests of the corporation? Well, here we have a very famous quote from a very famous case in the corporate law arena, Dodge versus Ford, and it says, a business corporation is organized and carried on primarily for the profit of stockholders. The powers of directors are to be employed for that end. So this illustrates the concept of what's called shareholder primacy. And shareholder primacy is essentially the idea that what is in the best interests of the corporation is always the financial maximization, maximizing the value of shares. Now, the extent to which shareholder primacy applies, it is subject to a lot of debate. And in any event, it does vary in different contexts. Typically, day-to-day decisions of management are given the most deference by courts. But once you get into, defensive actions and, if corporate control is up for sale, then courts do tend to focus more on shareholder primacy. But in any event, the way in which, the traditional legal framework applies to social enterprises, the way that courts will apply them, it's uncertain. And this can be illustrated by a case that happened right around the creation of the benefit corporation, which is only within the last 15 or so years. The case is eBay Domestic Holdings versus Newmark. And essentially what it was on one side, you had the founder and CEO, the two majority shareholders of Craigslist. And on the other side, you had eBay, a minority shareholder of Craigslist. The founder and CEO of Craigslist, they viewed their company more as kind of a community service, a public good, as opposed to, a strictly commercial profit-seeking enterprise. And they got into a dispute and eBay prevailed. And part of the court's reasoning here is up on the screen. Directors of a for-profit Delaware corporation cannot deploy a rights plan to defend a business strategy that openly eschews shareholder wealth maximization, at least not consistently with the director's duties under Delaware law. Now, today's presentation will not focus on Delaware law, but this does just illustrate the need for a new corporate form, the need for a benefit corporation that allows management to consider non-financial interests. So that brings us to what is the benefit corporation? Well, to be clear, it's a for-profit corporation. As a for-profit corporation, it has owners and shareholders. It's not limited in its economic potential or activity. The business itself can generate unlimited profits, and owners and shareholders can receive unlimited, dividends and distributions, just like any for-profit corporation. But a benefit corporation is also subject to additional statutory requirements. A benefit corporation has additional required purposes, different fiduciary duties for management, officers, and directors, and an obligation to report on its pursuit and accomplishment of its social and/or environmental objectives. So here you have some kind of big name examples of benefit corporations, just to illustrate, benefit corporations, these are not nonprofit corporations. They do have, a different purpose than just a strictly for-profit corporation. But none of these are Illinois benefit corporations, but just to show they are, everywhere in the world around you. And as I mentioned, those are not Illinois benefit corporations, but the vast majority of states, they do have either a benefit corporation law or some variation or kind of offshoot or subset of the original benefit corporation concept. So, these variations include the public benefit corporation, the sustainable benefit corporation, social purpose corporation. There's a lot of different variations. Today, I will be focusing specifically on Illinois law and the Illinois Benefit Corporation. But regardless, all of these different offshoots and variations, they generally share the same three defining features. The first is purpose. Generally, the corporation must have a purpose that benefits the public in some way. Accountability, expanded fiduciary duties for management that require the consideration of non-financial interests. In transparency, there's an obligation to report on social and environmental performance. So as I mentioned, today I will be focusing specifically on the Illinois Benefit Corporation Act and the laws of these various states. Other than those three key features, they do vary to differing degrees. But so everything moving forward today will apply specifically to the Illinois Benefit Corporation. So the starting point for understanding, what is a benefit corporation? What does the Benefit Corporation Act do? The starting point for understanding any aspect of a benefit corporation is just the regular Illinois Business Corporation Act that applies to all corporations in Illinois. And a benefit corporation, it's still a corporation. That's kind of the default starting point. It's subject to the regular Illinois law, corporate common law that applies to corporations in Illinois. But a benefit corporation then also voluntarily elects to become subject to these additional statutory requirements. So before we get into the specific features of the benefit corporation, let's talk a little bit about how do you have a benefit corporation? And there's two ways. You either start a new business, a new corporation as a benefit corporation, or you have an existing corporation and you elect to become one. So if you're starting a new corporation, as I mentioned, the starting point is always what you would do with a normal traditional corporation. You file articles of incorporation, a charter with the Secretary of State to organize the corporation. But the articles of a benefit corporation, they must also specifically state that it is a benefit corporation, and they must also include additional purposes. Now, if you have an existing business and you want to convert to a benefit corporation, or if you're involved in a merger or consolidation, share exchange, and the surviving entity is to become a benefit corporation, again, all that is really required is amending the articles of incorporation to state those two things. But of course, the amendment to the articles will need to be approved. And the Benefit Corporation Act requires them to be approved by what's known as the minimum status vote. So there's really two basic requirements. The shareholders of every class or series are entitled to vote, and the 2/3 of every class or series must vote to approve the action. So essentially, everyone gets a say, and 2/3 must say yes. So that brings us to kind of the first key feature of the Benefit Corporation Act, the benefit corporation purposes. So benefit corporation must have the purpose of creating a general public benefit, and it also may identify one or more specific public benefits. Now, a key thing to keep in mind as we move forward with examining kind of the rest of the statute and features is this provision C here that's in bold. The creation of general and specific public benefit is in the best interests of the benefit corporation. So, as I mentioned, traditionally, the best interests of the corporation are considered to be just the financial interests of the corporation. But the statute here is explicitly making clear that the best interests of a benefit corporation not only include financial value and shareholder wealth maximization, but they also include the general and specific, if there is one, public benefit purposes. So as I mentioned, the starting point is always Illinois Business Corporation Act. A corporation can be organized for any lawful purpose. Then a benefit corporation also must have the mandatory additional purpose of creating a general public benefit and has an optional additional purpose of creating one or more specific public benefits. So what is general public benefit? I've already said that phrase a number of times. So what does that mean? Well, the definition here, a general public benefit means a material positive impact on society and the environment, taken as a whole, assessed against a third-party standard from the business and operations of a benefit corporation. So that's definitely a little bit of a mouthful, but I think the first key thing to understand here is the taken as a whole language. The intent is for the positive impact of the benefit corporation to be viewed holistically. As we'll see throughout today's webinar, the Benefit Corporation Act is intended to be flexible. So, it kind of establishes guardrails, but the benefit corporation has a lot of latitude in kind of reaching that final destination of material positive impact. And then what does material positive impact, what does that mean? Well, a key language here is assessed against a third-party standard. The third-party standard is really what provides objectivity and provides meaning to this definition of what it means to create a material positive impact on society and the environment taken as a whole. Now, a benefit corporation can also have an optional specific public benefit purpose. You can see here on the right side of the screen that's directly from the statute. That's the definition of specific public benefit. As you can see, the first kind of 6 things listed are in a lot of ways more examples. And you can see number 7, the accomplishment of any other particular benefit for society or the environment. So the statute really gives, again, a lot of flexibility in determining, a specific public benefit purpose. Again, it's not required, it's completely optional, but, perhaps a nonprofit is something, you were considering, but the lack of, economic potential, it really, you shy away from the nonprofit because of that. Well, you might consider starting a benefit corporation that has a specific public benefit purpose, that addresses the same, charitable or educational, nonprofit purposes that you had been considering with a nonprofit. So it gives you a lot of flexibility in crafting, the mission and purposes of the corporation. So that leads us to our second key feature of the benefit corporation, and that is transparency. So, as I've alluded to, what it means to create a general or specific public benefit and what a material positive impact on society and the environment taken as a whole. These things are subjective, on their face. And so what distinguishes benefit corporation? How does the statute allow benefit corporations to distinguish themselves from greenwashing? Greenwashing, I'm sure you've all seen it, whether you know it or not. It's branding or marketing designed to convey a false or misleading impression that a business that's, not environmentally or socially responsible, it conveys the false impression that they are. So that's where the third-party standard and the annual benefit report come in. They inject objectivity into the meaning of all these things. So the third-party standard it provides a means to objectively measure the benefit corporation's impact. And in many ways, you can kind of think of the third-party standard as distinguishing the internal governance and operations of the benefit corporation from greenwashing, from the internal perspective. And the annual benefit report provides a means to objectively evaluate a benefit corporation's impact. And you can kind of think of that as distinguishing from greenwashing from the outside perspective, from the perspective of potential customers or suppliers or potential employees, et cetera. So what is the third-party standard? Well, here we have the definition. It's the standard for defining, reporting, and assessing the overall corporate, social, and environmental performance of the business. Now, the statute does not identify a specific third-party standard. Again, you'll see the flexibility of the Benefit Corporation Act in the Benefit Corporation form. Benefit corporations are free to choose any third-party standard that meets the statutory requirements. All the statute does is delineate what the third-party standard must assess and the requirements, for the third party that establishes it. Again, it establishes guardrails for the third-party standard. So what does the third-party standard do? Well, it must comprehensively assess the impact of the business in its operations on these four things: the employees and workforce of the benefit corporation, its subsidiaries and its suppliers, the interests of customers as beneficiaries of the general or specific public benefit purposes, community and societal considerations, including those of each community where the benefit corporation has offices or facilities or its subsidiaries or suppliers are located, and the local and global environment. So, as I mentioned, the definition of general public benefit, it includes that phrase assessed against a third-party standard. So in many ways, you can think of these four categories of interests and factors as kind of part of the definition of what it means to create that, material positive impact. These four factors really help define and delineate and kind of inject that objectivity into, how you determine whether, the material positive impact has been created. So then what does this third party part mean? Well, so the third party standard, the standard can't be developed by the benefit corporation itself. It needs to be developed by a third party entity. And that ensures that the standard, again, it actually injects some objectivity into the meaning of general public benefit. So the third party standard must be developed by a third party that's independent, credible, and transparent. And this ensures that it's objective and reliable. So what does it mean for the third party to be independent? Essentially, it just means the third party is free from any conflicts of interest. The third party can't have a financial relationship with the benefit corporation or its subsidiaries. It can't be, financed by or controlled by, businesses in that industry or businesses, whose performance is measured against that standard. The idea is that there shouldn't be any circumstances that could even potentially call into question the objectivity of this third party. And the third party must also be credible. It must access the necessary and appropriate expertise to actually be able to assess overall corporate, social, and environmental performance. In doing so, it must use a balanced multi-stakeholder approach, including a public comment period of at least 30 days. And the idea here really is that, to show that it's credible, the third party has to have taken kind of a careful and deliberate approach with input from a variety of different stakeholders in order to actually develop a standard that can credibly be said to, assess those factors that I mentioned. Finally, the third party must be transparent. Essentially, it must be transparent about the two things I just discussed, the independence and credibility. So, it needs to make certain information publicly available so you can actually know that, hey, this third party, it's reliable, it's credible, in the standard that it developed, we can rely on. So, the factors that it considered, kind of how it developed the standard must be made available. The, who controls the third party must be available. And importantly, who finances the third party must be made available. So that brings us to the next key part of transparency, and that's the annual benefit report. So the annual benefit report is an annual report describing and assessing a benefit corporation's environmental and social performance. And really, the annual benefit report, it's really analogous to financial statements, yearly financial statements. So financial statements provide objective metrics and information needed to evaluate a corporation's financial performance. Shareholders, as owners of the corporation, they vote on directors and in management, and shareholders can use the financial statements to evaluate how is the corporation being managed, from a financial perspective. Well, the benefit report, it provides objective metrics and information for shareholders to be able to evaluate, directors' social and environmental performance. How are they doing at achieving these additional purposes of the benefit corporation? In a similar sense, from a potential investor would look at yearly financial statements to get a sense of, how is this corporation doing from the perspective of financial health? Will I get a financial return on my investment if I invest in this corporation? Well, the benefit report for investors who are, impact investors or socially conscious investors who are looking to get, in addition or maybe even in lieu of a financial return, who are looking for social returns, the benefit report has that same advantage of allowing them to evaluate, if I invest in this business, will I, receive the social returns that I'm seeking? So what must the annual benefit report contain? Now, again, all of this really kind of relates and ties into one another, all these special features of the Benefit Corporation Act. And so the annual benefit report must include an assessment against a third-party standard. And you can really think of this as more of the quantitative part of the annual benefit report. It's not necessarily a one-to-one comparison to, the numbers in a financial statement, but the idea is to provide kind of objective metrics and information needed to evaluate performance, social performance. The annual benefit report must also include information about the use and selection of the third-party standard. So, it must describe the process and rationale. How did we land on this third-party standard? There's many different standards that are out there. And as I mentioned, benefit corporations are free to choose any third-party standard. And the annual benefit report, it must have its assessment against the third-party standard. It must be either applied consistently each year, or if it hasn't been applied consistently, it needs to explain why it hasn't been. And then we have the annual benefit report must include a narrative of, the ways in which the general and specific public benefit was pursued, the extent to which it was created, circumstances that hindered their creation. And in this sense, it can kind of be thought as more of the qualitative information that shareholders or other members of the public, whoever reviews the annual benefit report, can use to evaluate the benefit corporation's achievement of its public benefit purposes. The annual benefit report must also include an opinion of a benefit director. And a benefit director is essentially an independent director responsible for, including this opinion in the annual benefit report. Illinois makes it mandatory. A lot of states make it optional. Illinois also makes it optional to have a benefit officer, which is a similar concept, an officer kind of responsible for the annual benefit report and fulfilling mission. So the opinion by the benefit director must be about, whether the benefit corporation acted in accordance with its purposes and whether the officers and directors complied with their special duties that we'll discuss here in a few moments. And finally, the annual benefit report, just to kind of ensure full transparency, it needs to include kind of some more miscellaneous director, officer, owner information, the name and address of the benefit director and officer, if there is one, compensation paid to directors, names of shareholders who own 5% or more, statement of any connection between the benefit corporation and the third-party standard organization. And this last one here, description of restricted powers of directors. Essentially, if the board of directors' powers are limited or restricted in some ways, it needs to explain, who has those powers instead. So what must be done with the annual benefit report? Well, it needs to be sent to shareholders annually, either at the same time as any other annual report is sent to shareholders, or I believe within 120 days after the end of the fiscal year. It must be made publicly available. So either it must be posted on the benefit corporation's website, or if the benefit corporation doesn't have a website, it must be provided for free to anyone who asks for it. Now, I should mention, because this may be a concern for some businesses and some people in the idea of making this publicly available, is that compensation paid to directors and other financial and proprietary information can be omitted from the copy that's made publicly available. And then I have a note here. Some states do require it to be filed with the Secretary of State. Again, just ensuring full transparency of the benefit corporation and its required purposes. So that brings us to our last key feature of the benefit corporation, and that is accountability. And the first aspect of accountability is director and officer standards of conduct. So as I discussed at the beginning, the starting point for understanding, any of the Benefit Corporation Act's special features is always existing corporate law, the law that applies to any corporation in Illinois. So as a general matter, all corporate officers and directors owe the corporation a fiduciary duty of care, which I've alluded to already. The fiduciary duty of care requires officers and directors to discharge their duties of their positions in good faith, with the care that an ordinarily prudent person in like position would exercise. And a big part of that is, a prudent person acts, they don't act recklessly, they act on an informed basis. So a director must act on an informed basis and in a manner reasonably believed to be in the best interests of the corporation. So if benefit corporations are subject to existing corporate law, unless the Benefit Corporation Act provides otherwise, well, then what does the Benefit Corporation Act say? So it says, in discharging the duties of their respective positions, the board of directors, committees, individual directors, in considering the best interests of the benefit corporation, shall consider the effects of any action upon, and then you can see 7 kind of categories of interests and factors listed. You'll notice the first factor is the shareholders. Just because the Benefit Corporation Act in the Benefit Corporation form is intended to kind of give management more flexibility and more latitude in considering non-shareholder interest, that doesn't mean that shareholder considerations are irrelevant. Shareholders still own the Benefit Corporation, and their interests still must be considered, in any action. Then these next 4 considerations listed, B, C, D, and E, you'll notice those are the 4 categories of interests and factors that are required to be assessed under the third-party standard. So as you can see, everything, all the special features of the Benefit Corporation, they all relate to one another. So, the Benefit Corporation must pursue or create a general public benefit. What does general public benefit mean? Well, it is partly, it means it's assessed against the third-party standard, material positive impact on society and the environment assessed against the third-party standard. Then these 4 factors, that's what is assessed. That's what it's assessed against. So the Benefit Corporation's directors, they don't just have to consider, the effects on the general public benefit purposes, but they actually have to consider these specific aspects, these specific factors that actually delineate the general public benefit purpose. So again, it all relates to each other. Now, provision F here, the short and long-term interests of the Benefit Corporation, including benefits that may accrue to the Benefit Corporation from its long-term plans and the possibility that these interests may be best served by continued independence of the Benefit Corporation. So this really, in a lot of ways, relates to, what I discussed at the beginning, for example, in that eBay versus Newmark case. And, it relates to a situation where it may be the short-term interests, what's best today from the financial health and, what will create the most financial value today isn't necessarily consistent with, the Benefit Corporation's ability to create its general and specific public benefit purposes over the long term. So this, it explicitly allows directors to consider, maybe the Benefit Corporation, even if, if for a short-term period or there's some, financial negatives, maybe it would be best served to, remain independent and not necessarily maybe sell to the highest bidder or whatever the specific situation may be. And then finally, kind of the more broad category, just the ability of the Benefit Corporation to accomplish its general and specific public benefit purposes. Now, directors may also consider considerations listed in Illinois' constituency statute and any other pertinent factors or interests they deem appropriate. And the key here is that directors need not give priority to any particular group or person that's, referred to in these 7 factors. So again, the statute, it's intended to be flexible, and really it's not intended to legislate results. It's intended to legislate process, and that's a really important thing to remember. So what are officer standards of conduct? Well, they're essentially the same. When an officer has discretion to act and it reasonably appears that, the matter may implicate the specific or general public benefit purposes, the officer must consider the same factors as directors do. Directors of a corporation set the policy of the corporation. Officers are responsible for implementing that policy and kind of the day-to-day. So, only when an officer has discretion to act and it's, relevant to the general or specific public benefit purpose, does this apply. But when it does, the officer must consider the same factors as directors do. So what do these, special standards, these unique modified standards of conduct do? Well, on the one hand, they essentially, as I think I've probably made clear by now, they expand the meaning of what's in the best interests of the corporation. Shareholders are still the first consideration listed, but the best interests of the corporation, now include all these other interests in factors in kind of categories of stakeholders. So the key point here, as I've probably emphasized, is the Act allows for decisions that do not solely maximize financial and shareholder value. Now, at the same time, as I mentioned, the Act, it's a process-oriented Act. It does not really legislate results. So what these standards of conduct also do is they essentially expand the concept of what it means to act prudently and on an informed basis. The Act doesn't establish how the various interests and factors should be balanced or weighted, and it doesn't say, one interest should be valued or factored in over others. It gives directors and officers a lot of latitude and flexibility, but it legislates process. It says you shall consider these factors. So, in addition to giving management protection, the Act also does impose additional duties in decision-making. So it does kind of expand the scope of what it means to have met their fiduciary duties. A couple of other key features of the standards of conduct is directors and officers do not have a duty to a person that is a beneficiary of the general or specific public benefit purpose, simply because they're a beneficiary of that purpose. The Act expands the duties of directors, but it does not expand the scope of who those duties are owed to. The management still owes their duties to the benefit corporation. And then also directors and officers cannot be held personally liable for monetary damages for actions that they take in compliance with their unique duties, or for the failure of the benefit corporation to pursue or create a general or specific public benefit. So ultimately, what do these special standards of conduct do? Is they protect mission while at the same time also protecting management. Management must consider a variety of non-financial interests and factors, but at the same time, the consideration of these non-financial interests and factors, it won't automatically result in liability. In fact, as long as management complies with their expanded duties under this Act, their actions won't result in personal liability under this Act. And importantly, just because the duties have been expanded, it doesn't mean that the scope of who the duties are owed to have also been expanded. So the final feature of the Act that I will discuss is enforcement. The Benefit Corporation Act creates a lot of special and unique features. And in doing so, it also creates a unique enforcement mechanism to enforce these features. All these unique standards and obligations, they're nice, but they wouldn't really have a whole lot of purpose if they couldn't be enforced. So how does the Act enforce these unique requirements? Well, it's through what's called a benefit enforcement proceeding. That's the only way that it's the only mechanism to enforce the Benefit Corporation Act's unique requirements. So a benefit enforcement proceeding is a claim or action that can be brought for one of two things: either the failure of the benefit corporation to pursue or create its purposes, or a violation of an obligation, duty, or standard of conduct under the Illinois Benefit Corporation Act. So it's specific to the Illinois Benefit Corporation Act. Who has standing to initiate a benefit enforcement proceeding? Well, it can be initiated directly by the benefit corporation or derivatively on behalf of the benefit corporation. A derivative suit is a suit brought on behalf of and in the name of a corporation when a corporation declines to bring that lawsuit itself. Typically directors aren't always willing to have the corporation sue themselves. So that's kind of where a derivative suit comes in. And a derivative suit can be brought by shareholders, directors, 5% or more shareholders of a parent company, or other persons specified in the articles or bylaws. So we have two different types of claims. So the first one is the failure to pursue or create. So what is the remedy for this claim, for this unique statutory claim? Well, a benefit corporation cannot be monetarily liable for a failure to pursue or create. And as I mentioned, officers and directors cannot be personally liable for monetary damages for the benefit corporation's failure to pursue or create. So what does that leave us with? That leaves us with injunctive relief. Injunctive relief is a non-monetary remedy. It essentially requires a party to take certain action or refrain from taking certain action. And the key thing to remember with the benefit enforcement proceeding is it's simply intended to force a benefit corporation to, live up to the voluntary commitments that it made when it elected to become a benefit corporation. It's designed to enforce these requirements that the Benefit Corporation Act creates. It's not designed to, create additional avenues of monetary liability. And in fact, the entire Benefit Corporation Act is not really focused on, financial performance. It's focused on social performance. So naturally, the intention of the benefit enforcement proceeding is to ensure social performance and to ensure, purposes are fulfilled and, the benefit corporation meets its transparency obligations, and the directors, consider the factors and go through the decision-making process that they are supposed to go through. It's not intended to create, additional avenues of financial liability. So the other claim is a violation of an obligation, duty, or standard of conduct under the Act. Now, to be clear, as I kind of alluded to, the benefit enforcement proceeding, it only relates to the specific standards, duties, obligation under the Benefit Corporation Act. So, it doesn't preclude lawsuits for things that are outside of the scope of the Benefit Corporation Act or, a violation of a duty or standard of conduct that's not directly, related to the Benefit Corporation Act. The intention is really to create, you have these unique features that the statute creates for purpose and transparency and accountability. So the benefit enforcement proceeding, it's a unique way to enforce those features. Now, one potential claim of a violation of an obligation, duty, or standard of conduct would be the failure of a benefit corporation's management to consider the delineated interests and factors. Again, the intended remedy is injunctive relief. In this specific circumstance, it's possible for monetary liability just because the directors and officers are exonerated, only if they meet their duties, and their duties require them to consider all these interests. So it is possible that the exoneration wouldn't apply. Having said that, it might be difficult to kind of establish all the proof and the damages necessary for a real monetary claim. But I do want to mention it. And here we have just other examples of potential violations of an obligation, duty, or standard of conduct. And again, as you can see, the default remedy for all of these is injunctive relief. The key thing to remember with the benefit enforcement proceeding is it's simply intended to ensure the benefit corporation meets its voluntary commitments. So briefly, I know we're getting a little low on time. Just to briefly recap 3 key features of the benefit corporation: purpose, legally required to benefit the public; accountability, management must consider non-financial interests and factors; transparency, there's an obligation to report, to objectively measure and report on social and environmental performance. And I will get into questions here in just a minute. But just to kind of go back to that poll at the start of, what are your objectives for being here? So now that we've gone through it, let's kind of revisit that. And so I know some of you had mentioned, you're considering starting a new business. So what the benefit corporation structure allows you to do is really establish guardrails from the start of allowing you to be equipped from the start to address what will be inevitable tension between purpose and profits. And then throughout, the life cycle of the benefit corporation, it'll allow you to really distinguish your business from, those that are just engaging in greenwashing. And it also will allow you to, attract outside investment without worrying that, they'll force profits to overtake purpose and force you to kind of compromise your social and environmental objectives. And another, really important feature is it provides you with a means to objectively evaluate and measure your mission and your social and environmental goals. And again, distinguish from greenwashing and give you confidence that if you have other investors or partners that financial and profits will not overtake purpose. And then just even way at the end of your business, the benefit corporation can have a lot of advantages for when that time comes that you're ready to exit. It can provide employees, customers, suppliers with certainty that just because you're phasing out, doesn't mean that your mission will phase out too. So with that, I will, looks like we have some time for questions. So if anyone has any questions, please feel free to type them there in the chat box, and I will answer them as they come up. If you, of course, think of anything after the presentation, I will have my contact information are going to be both in the slides, and the slides will be emailed to you under the email address you registered with for today's webinar. So you can always feel free to reach out to me after as well. So while I wait to see if there are any questions, I will just want to thank everyone for being here today. I hope you learned something. You have some contact information up on the screen here. This is my email right there, Jeremy Kritt or J Kritt at Marc J Lane. Okay. Oh, so we have some comments in here. Thank you. Has he established or recommend so we have a question. Mr. Lane is an international authority in social entrepreneurship. Has he established or recommended a third party? So I believe you're referencing the third party standard. Mr. Lane has not established a third-party standard. There's a variety of third-party standards. As I mentioned at the very beginning, B Corp certification is one of them. There's also some kind of more industry specific third-party standards, or geographically specific third-party standards. So there's a lot of different considerations and factors that would go into choosing one. The cost, the complexity, the reliability of it. So no, Mr. Lane has not established or a third-party standard. In the specific one that we would recommend would really depend on the specific business. Can I give an example of a benefit corporation in Illinois? I'm trying to think of one offhand. It's escaping me now, but I can go ahead and email you an answer. And it looks like that is all the questions I've gotten. So I'll just thank everyone for coming. You can check out Mr. Lane's supplement on the topic. And little disclaimer here for the information provided today.